It is my pleasure to welcome you all to today's research seminar, a platform for fostering innovative ideas and academic dialogue. It's a very special occasion because it just happens to be the Hong Kong Tech 300 program, and the topic of today's research seminar just is perfect for this occasion. So we are delighted to welcome Attorney Raymond Szeto, General Counsel and Chief Technology Officer of AI Innovations Incorporated. A Harvard Law School and MIT computer science graduate, he has shaped intellectual property strategies for multi-billion-dollar acquisitions at Broadcom and IBM. As a patented inventor in optics, Mr. Szeto offers a unique perspective on how corporate buyers evaluate intellectual property. Today's seminar will explore the role of IP in technology transactions, drawing from examples involving industry leaders like IBM and Broadcom, and the section will surely inspire those passionate about IP law and innovations. Please join me in welcoming Attorney Raymond Szeto to the stage. And on behalf of City University of Hong Kong, I am delighted to present Raymond with a limited edition CityU HK Camo Thermals. Since 1940, Camo has crafted glass vacuum flasks, resonating with CityU HK's pursuit of material science research. Bearing the CityU HK logo, this keepsake symbolizes our shared commitments in innovation. Please accept this as a token of our appreciation. Oh.
Thank you very much. Oh, thank you, Professor Shum.
Yes. So we now move to this highlight of today's event. Mr. Szeto will deliver his seminar on Unlocking Innovation, how big companies assess startups and explore intellectual property licensing. Please join me in giving him a very warm round of applause.
Thank you. Thank you very much for having me. Thank you, Professor Shum. Thank you, Professor Goh, Ms. Yi, and all distinguished guests and students. Thank you. I'm truly honored to be here today, and I'm very grateful for this time and opportunity to have this conversation with you. It's a privilege to speak for such a thoughtful and brilliant group. I didn't realize that HK Tech 300 was taking place right now, and it's just amazing. I am completely flawed. Thank you. So my name is Raymond Szeto. I'm a US-based intellectual property attorney. I do much of the work in helping large corporations evaluate intellectual property for acquisition and figure out what assets to purchase and not purchase. And in preparing for today, I thought it would be helpful to share in the room of brilliant intellectuals sort of some practical insights I've acquired over my career on what is a good way to position your intellectual property for later acquisitions down the line. Because oftentimes, I think a lot of you, as you're starting your companies, you're thinking about your exit plan even. You're thinking about retiring on the beach of a private island. And so, you want to know, well, that's usually generally involves a big company acquiring you. And so how do you position yourself to maximize that? So before I get into my background, I'm going to begin with a little story. So let's start with a story. Imagine a beautiful day, much like today. And it's not as hot as today because in the US everything is cold. So you're a mid-sized tech company and you received a phone call. And the phone call is about money. It's about acquisitions. And in this acquisition, you found out you're a founder and you're ecstatic because a large tech player, in this case IBM, came to you and were ready to talk about acquiring your business for hundreds of millions of dollars. This is actually a real case that I was involved in, but I have to scrub certain things for confidentiality. And so you got the phone call, it's great, and I like to think that the founders at that time were just dancing on their desks, they were happy, they just, this is their exit plan. They have finally, after 10, 15, 20 years of hard work, are going to be rich, and they're done. And they're ready to retire. Now, I don't know if this happened because I'm on the buyer side. I don't see this, but I like to think that's what happens. So at this point, they're ready for the acquisition. They're getting ready, they're happy. And the thing about acquisitions is, whenever it involves a large public company, in this case the buyer, or especially in a case if it is two public companies, it's very secretive, ultra secretive. In fact, we would go in there with code names. There is a cover story. It goes into a nondescript conference center. No one outside of the team knows what's going on. And the executives come in on separate flights, and we're just very quiet about what's going on. And we're there for maybe a few days. And during those few days, we would evaluate everything inside the target company. We would evaluate your contracts, every single contract you've ever signed since the beginning. We would evaluate your software. We would look at every line of code and figure out what's actually in your code. We actually started this a few weeks before. And the conversation is generally about what we found. And then we would evaluate your teams, your leadership team. And the reason is we want to make sure that when we acquire a company, we're also acquiring people. And we want to make sure there's a good fit in personality and culture. And so we have, when IBM comes in, well, when large companies come in, it's a large team. And this large team will be filled with human resource. It'll be filled with general legal. There'll be an intellectual property attorney team there as well, and finance. Everything you can think of to make a company run will be there. Now, how do you keep such a large team and still keep it secret, right? Well, what happens is that each team brings in the lead, and about a dozen or 2 dozen people are at present, and we lead the diligence. So after the diligence of 3 days, 4 days, they got a phone call, and the deal didn't work. We canceled the deal, and we thanked them for their time. It didn't work out, and sadly, it was a disappointment for the founders. So what happened? What happened to cause this? So the question I'm going to ask is, I want to just do a quick survey. How many people think that the reason this deal failed was because of litigation, like a lawsuit? Any people think it might be, okay. Any people think it might be a finance issue? Perhaps the numbers just don't work out. Okay. Any people think it might be a case of contracts? Maybe there's just some contracts in there that doesn't work very well. And okay. And then the last question is, maybe how many people think it's a patent issue? Maybe it's a problem with a patent problem. Okay. Well, you're all correct to varying degrees. All those issues oftentimes do cause problems. But in this case, the entire $100 million deal failed because of a single contract. And what it was a contract they signed way back in the beginning, and it caused terms that makes this company completely non-acquirable. And I'll go into the story a little more later as we talk about this. So at this point, I'll talk a little bit about my background, and just that way you can have a sense of where I'm coming from with these issues, through what lens I'm thinking about these issues. So I was an intellectual property attorney. I worked at IBM I had the wonderful opportunity to work at IBM to be part of their acquisition teams. I was a product attorney. I helped acquire different companies. Some deals were $100 million, some were tens, some were billion-dollar deals. And I also then later on went on to Broadcom, where I worked in building patent portfolios and acquiring the actual property licensing of patents. Before that, I was actually an attorney at a couple of law firms, Fish & Richardson and McDermott. And prior to that, and I raised this part of my background because I know there are brilliant scientists among us, and if you want to ask questions and you're not sure where my knowledge of science is, I'm just giving you a little background on that. I was a computer science engineer at MIT. Later went to Harvard Law School for my law degree, and somewhere in between, I studied medicine at Columbia. So I could talk a little bit about immunology, but only a little. Okay, so so this is going to be the roadmap for today. I'll just try to keep it very concise. I'll give you a quick overview of what intellectual property is. It'll be 1 minute. And then we'll jump straight into answering the specifics of what do you need to watch out for from a buyer perspective. So we're going to talk about acquisitions, standards, open source, and then what we normally think of as direct licensing. And then after that, we'll wrap up with a question and answer session. So I'm going to talk about each of these topics in addressing two different groups. There is overlap. The first group is the patent holder. And the patent holder could be the university, where you hold intellectual property for the university. It could be you as an individual inventor later on in life, and you're a patent holder. Or it could be, perhaps, it looks like a lot of entrepreneurs here. When you start a company, you want to know what issues that you need to worry about. Okay, so intellectual property. Intellectual property generally is thought of into four main categories. The first one is patents. When you think of intellectual property, you think about ideas, inventions, new drugs, new machines, new chemical compounds. And all of these are usually considered protected under the realm of patents, which are things that are useful. Another thing that's very common in protecting intellectual property in big companies is copyrights, which is very surprising. Because when I was a young attorney at the law firm, my whole entire life was patent. It was patents day in, day out, morning to night. And you think that was all of it there was to intellectual property. But when I went in-house, it was the exact opposite. Most of my work was actually in copyright because software is copyrighted. And that's how software is protected. And everything you need to know about working in large tech companies where you have software is about licensing. There's two other areas of intellectual property. There's trademarks and trade secrets. And I won't touch on these very much because they're generally not the issue, but I did find out that some of you work with AI, and a lot of your AI work is behind the scenes. So I can talk about trade secrets because I have a feeling you'll be protecting yourself using trade secrets for that area. So acquisitions. My thought about this talk was, how do I help you monetize your ideas, your inventions, in the easiest way possible? And the way to do it is through acquisitions. Now, I'm going to take a brief diversion and talk about something else. So in your pocket, you probably have a cell phone. And this cell phone, I got this on sale. It was like $1,000. I think actually it might have been on sale for less. I got a really good deal. And so in the cell phone, I bought it, and I didn't really think much about the IP behind it. Inside this, let's say it's $1,000, inside the cell phone, you probably didn't realize there's probably a few $100s of intellectual property transfer happening behind the scenes. There is a video decoder that is part of the H.264 or 265 standard. There are touch controllers. There is Wi-Fi. Wi-Fi is part of 802.11a, b, g, c, a, c, or n. There is the baseband controllers that's generally acquired for your digital communication with your videos. And that's GSM or CDMA. So there's so many, there's even a FM radio circuit in here. And there's power controllers. And all of these standards, even the port, this USB-C is a standard. And each of these things, someone gets money for. And when I bought this for $1,000, I didn't think twice about it. And that is the easiest way to get monetize your intellectual property. Build it inside something and wrap it inside. So that's the path of least resistance is the way I would recommend it. So the way, in terms of intellectual property, the path of least resistance is a business. It's an acquisition. So if you manage to put your intellectual property, your inventions, inside a business, and when a large corporation comes and purchases it, it just goes straight in. We won't even look twice behind it. Now, because what happens is that when I'm doing due diligence as a large buyer, I look at hundreds and hundreds of thousands of contracts. It's not just me. Depending on the size of the acquisition, there may be a team of 10 patent attorneys behind me. On the general legal side, there's probably another 10 attorney on that side, and we're reviewing tons of contracts. And so, if your intellectual property built inside is a royalty contract for 1% of whatever revenue, or 5%, it just automatically slides right in, and no one even knows. And as long as the transfer is simple, as long as it's easy to go along with the acquisition, perfect, you're done. You actually just increased your revenue because now you're part of a larger corporation who may need to pay more royalties. Now, in this case, I wanted to mention a few things about acquisitions. It's sort of what are things that you need to worry about from the perspective of a patent holder and also from the perspective of an entrepreneur. So remember this scenario? I mentioned the story earlier. There was a single contract in there that ruined everything, that ruined the $100 million acquisition. And I was thinking about how much I can talk about it because, confidentiality. And I realized that, okay, I can mention this. When you first start a company, when you're first starting off and you're trying to build your company, and you would sign any contract because you need to make the company work, and you build it up. The challenge is the contracts you sign may tie you to that company, and you may never be able to be acquirable. So what do I mean? Going back to the cell phone. Let's say you build software that works only on the Apple iPhone system. Now, I chose Apple. This, by the way, the company wasn't Apple. It was another company. Because when you're at that level of technology, of large technology companies, they're all competitors of each other. So for example, Apple is a competitor of Google. Apple sells adware. They're competing Google with Android system. Apple is a competitor of Netflix. They are both selling streaming services. Apple is a competitor of, well, used to be a competitor of IBM. They're less so now. They're more partners. Apple is a competitor of Facebook. Apple is a competitor of all these other companies. So that means if you tie yourself to this one system, one ecosystem, you may accidentally make yourself less acquirable 15 years down the line. Because let's say I am Google, and I'm trying to acquire this company for their technology in securities. Well, they sign an agreement with Apple, and the Apple says, I won't let you sell this. If you try to sell the company, you can't use my intellectual property. And at that point, you're stuck. The company automatically becomes worthless. So for entrepreneurs, be careful about this. If there's anything I want you to take away from this talk today, there's two things. This is the first one. Be careful when you sign early contracts. And if you ever tie yourself to a single company, whether it's a vendor for procurement, whether it's a technology, it's hard in the beginning because you don't have a choice. You want to start your business, and business drives everything. But from time to time, evaluate how much you're tied to a certain ecosystem and whether or not those agreements give you the freedom to be acquired. Because that's actually what happened in that company that ruined the deal, was they couldn't be acquired. They were tied to one company that was a competitor. Now I'll direct my talk to the patent holders about acquisitions. So if you manage to get your IP inside a small company, that's great, because now when they get acquired, you automatically go along for the ride. You're going to sometimes, if your terms are not overly burdensome, if their terms are not too difficult for transfer, it actually should be easy to move over. However, you could play a little game here at this point. You can try and make your terms slightly burdensome so that you can renegotiate the terms. You can make your terms tiered. There are different things you could do to essentially extract more value when the company gets acquired, so you can enjoy some of the benefits of the acquisition. This is what I would recommend. If you develop a reputation for being negotiable, that you can actually, you're open to negotiations, this should be able to help you extract more value for your IP that's currently going into an acquisition. Now, how do you know the company's being acquired? They may quietly come to you for renegotiation of terms. And if that happens, there's a good chance I don't know there's a good chance they're being acquired or they're being evaluated for acquisitions. Because what happened is, when a large company looks at these companies for acquisitions, we can't tell the world that, oh, so-and-so with big, deep pockets are coming and they're looking to acquire you. Because at that point, it's going to be hard to negotiate. So we tell the target company, try and quietly renegotiate these terms. And if you can renegotiate it so that I can transfer it over, great, and then we'll acquire you. The next thing I'll talk about is standards. Now, I'm not sure the level, how familiar you are with standards, but standards are essentially what I call power by numbers, meaning you are part of a bigger pool of patent holders, of IP holders, and you are now the 800-pound gorilla. You can stop people from doing certain technologies, and because of that, people will pay you. So one classic example of standards is, as I mentioned earlier, video decoding. When you buy when you buy a MacBook, I believe that the video decoding module, the H.264, H.265, is not automatically built in, so you need to download it. And that's because there's a standards involving for the encoding of the video and decoding of the video, because encoding and decoding need to be standardized. And then the standard holders, the encryption people, the compression people, want to have a low money for that information or that intellectual property. If you work in, now it sounds like everything we talk about is about technology, and that's not the case. Think about standards as if you're in medicine or if you are in chemistry, if you convince a government or a government agency or a hospital to use your product, and if everyone uses your catheter connector, or if everyone uses your method of evaluating drug delivery, you become a standard. And so with that, you actually have the exact same power of standards. And so I would strongly recommend, if you can, become part of a group. And if there is no existing group, make your own group. Now, I have to say it is hard. Creating a standard is a hard job because it takes a dedicated team of a few technology people. They have to attend certain meetings and to essentially lobby for your technology to be part of the standard. Now, once it's part of the standard, everyone who wants to use this technology will have to implement it in this exact way, which means they will exactly infringe your patent. And there you go. And you can actually negotiate different terms for royalties. The third thing I'll talk about, and this is actually very particular to the entrepreneurs, but it's also strategic for the patent holders, and it's about open source. You may be surprised, I was surprised when I first joined the company, that most of my work is open source. It's copyright. It's not patents. When I was training as an attorney, an IP attorney at law firm, my day and night was all patents. Day and night, I file patents, I argue patents, I talk to the patent office. It was all about getting the patents. And I thought that was all there was to intellectual property. But it turns out in a company, it's more business-oriented. It's about products. And products are built with software. So this slide talks about different licenses of open source software. And of course, as you've noticed by now, most of my slides are just pictures. And so I thought I should put some words around there. I won't talk about each of these individually. You can ask me questions later. But different different open source licenses have different terms. Some of them are viral. I will talk about that if you're a company and you're trying to sell your software and you use GPL, a GNU public license, we probably would not buy it because it means that all your software is infected with that same license, which means you have to make it public, which means you have nothing I can sell because it's free. On the other end of the spectrum, the MIT license is very permissive. It's essentially an authorship license. You use it, you just give credit where credit is due, and that's it. And then one right above it, the Apache license, I would make a precaution. The MIT license doesn't necessarily give up your patent rights. So let's say you create a new compression algorithm, right? You spent your entire PhD thesis, you found this great new way of compressing numbers and encoding it, and now you've built this module. It compresses and decompresses 100 times faster than what's out there, and you put it under the Apache license. What you just did is you can no longer protect, monetize your patent that's related to it. But if you put it under MIT, you can. So there's different, I put it from the most restrictive to the least restrictive. And there's different versions, but we can talk about it later if you're interested. That's actually the last of the slides with words. Back to pictures. Well, a little words. So direct licensing. Oh, actually, I'll go back a little bit about open source. So why did I talk about open source? It has to do with if you're an entrepreneur and you start a company, you're most likely going to use a lot of software. This software is going to be open source because you need to be compatible with, say, the Apache server, or you need to use Bounty Castle for your cryptography, or you need to use OpenSSL for your connections. And each of these software comes with a license. The danger, the trap, is these software also pose in other software. They pull in other software that has other licenses, and those software pose in other licenses, and it's a giant rabbit hole, and it goes deeper and deeper. And you do need to at least have some understanding as to what kind of software you're using. The second thing I want to warn the entrepreneurs here is a lot of open source licenses have patent problems. One patent problem is TensorFlow. There's a general understanding in the community that TensorFlow may infringe some patents. I won't go too far into it, but you can you can do some research on that. OpenSSL used to have a patent problem. Depending on the company who's looking to acquire you, they may have a litigation problem that also has patent problems. So knowing what open source packages you have in there will impact the valuation of your company. It can actually completely kill your deal, as it has in the past. And I would say, during my time of all the acquisitions I worked on, more than half of the problems came from open source, surprisingly. Probably closer to 70%. Now, for the patent holders, what do I want to mention to you about open source? How does it even relate to you? Well, remember earlier I said it's nice to just package your technology, your intellectual property, your inventions, and just slide it in and no one notices? You could package your invention in an open source package. And just be careful how you license it, because you may give up your patent rights. But if you want to develop a standard that everyone wants to use, you build a product, and then you just give it out, people start using it, and pretty soon you become a standard. So this is another way of becoming standardized in a sense. Then the last thing I'll talk about is direct licensing, which is what I think most people think about when it comes to intellectual property licensing. Direct licensing, I would have to say, is absolutely the hardest job I've ever had as an IP attorney. It is very hard because, remember earlier I said if you want to make money, you go where the money is. You make things easy for companies to make money. So if acquiring a company for a large corporation is new revenue. New revenue reports on the 10Q quarterly filings. So it looks great for the stock market that increases the price. That's what their objective is. If you're licensing, you're doing the exact opposite. You're asking the company for money, and companies don't like to give away money. So what you do is, if you can, look into the other three approaches of trying to sneak your IP in there and monetize that way. But if you do want to go directly, there is ways. One way I would think about it is you package it. You package it as part of a large bundle of technology, and it's related enough. And then you approach the company and say, would you be interested, wink, wink, in exploring, in purchasing or licensing these technologies from us, these patents? Now, granted, there's 1,000 patents. 2 or 3 may interest you particularly. And those 2 or 3 actually read on exactly what they're doing. And that's actually how large companies do licensing. They build a giant package, and they license an entire package portfolio of that technology. And of the 1,000, actually, I'll tell you a story that actually happened. So some years ago, Facebook, when it first started, Facebook was about 3 to 7 years old, was being sued by Yahoo. Facebook didn't have any patents, and so they had no protection. Yahoo at that time was an older company. They had tons of patents, and Yahoo sued Facebook for patent infringement. What's Facebook to do? My thought is, if Yahoo sued Facebook a year earlier, or maybe 2 years earlier, there wouldn't be a Facebook. What happened, though, was Facebook had money at that time. About 5 years out, they had millions of users, they had billions of investment, and they had one of the investments from Microsoft. And with all that money, what did they do? They went and purchased patents. Just so happens, you go to an old company like IBM or Microsoft, and they purchased 750 patents from IBM and about 1,000 patents from Microsoft. The amount they purchased it for is not disclosed, but the general consensus thinking is the patents were, and by the way, all these numbers I give you is US dollars, so the patent price was probably between $100,000 to $1 million per patent. And so Facebook spent a lot of money to have patents that read on Yahoo, meaning they can now sue Yahoo. So if Yahoo wants to sue Facebook, it's mutually agreed, mutual destruction. And that's how they protected themselves. So if you want to do direct licensing, the idea of packaging is a good idea. Now, what is the typical scenario for when you come into a company and you want to license to us? Well, I'll tell you my day-to-day. Normally, you would, let's say you have a patent, you say, oh, so-and-so, we would like to see if you're interested in licensing this patent. It goes through the technology office, and that technology office says, this looks like it is related to Microsoft Office or Office applications. And that was one of the product lines I was in charge of. And so I would get an email or someone would tell me that I need to look at this patent to see if we infringe. Already, I said we infringe, meaning we're looking at it from a confrontational perspective. We're not looking to to license if we don't have to. We actually don't want to pay money. We're looking at to see if we do even need to license it. So my job is, I would take maybe a couple weeks. I do address it. It's just I have other work to do too. So it takes me a couple weeks, 3 weeks, or some number of weeks, and I review it. I talk to the engineers, the development team, and I find out what do we actually do, and does the patent read on our product? And if it doesn't, we say thank you, but we're not interested. And that's the letter you get back. And the reason I'm telling you this story is because there was a very special scenario that happened to me once. And remember earlier I said if there's anything you want to learn from this session for the entrepreneurs, there's 2 things. This is the second thing. So it was a fall afternoon. Actually, it was about noontime. My boss came into my office, Steve, and he said, hey, Ray, what are you working on right now? And I told him. And he says, OK, stop everything you're doing. I need to focus on this issue for the next 3 hours. And I thought, Steve, is everything OK? What's going on? And he says, we received a patent that is being asserted against us, and it comes by way of the CEO of IBM worldwide. The person, instead of submitting it through the normal channels of licensing, submitted somehow to the very top guy at IBM. That CEO then seeing it's a legal issue, contacted the general counsel, Bob. Bob, seeing it's an IP issue, contacted the head IP attorney. Dave, realizing that it's an issue to do with my division, contacted the regional manager for this division, my boss, Steve. Well, actually, he contacted with software, so he contacted the head of software group worldwide. Mark contacted Steve, Steve contacted me. So in doing that, not only is it just normally my boss knowing what I'm doing, is my boss, my boss's boss, my boss's 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 boss, my boss's 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 boss, all the way to the top guy at IBM. And I can guarantee you, that work got done not in 2-3 weeks, but in 3 hours. And so, what is that lesson there? That means that if you want to get something done fast, hit everyone's head on the way down. Just hit everyone. And that actually summarizes my talk, pretty much. We talked about if you want to quickly make money from your IP, build it into a product, do it via acquisitions. If acquisitions are not what you're looking at, build it into a standard, because there's powers in numbers. Because oftentimes, your patent is looked upon, and they will try to find ways to design around it. But if you have a lot of patents together, they can't design around everything. So build it into numbers. Third thing, review your contracts. know what you're actually signing up for. And if you need to, find workarounds or renegotiate the contracts. And lastly, the most important thing is if you lose your luggage at American Airlines, don't contact the CEO of American Airlines. There's actually a website for that. But I don't want to get in trouble. So that's it. Thank you very much for your time. And I'm open to any questions you may have.
Thanks a lot. So any questions from the audience? Yes, please. Can we pass the microphone to?
Wonderful talk. Just a quick question. How do companies come up with their valuation? I mean, you talked about that company coming up with a $100 million valuation. How did they come up with the figure?
Okay, that's a wonderful question. So the question is, how do big companies come up with valuation? So I'll give you a little insight as to the way these deals are done. It has a lot to do with the corporate structure. When the deal starts, there's a division at these large companies called biz dev. And business development has one job, which is to buy companies. The company generally has a large pile of cash sitting around, and they just look to buy companies. And each year, they actually have a target. We need to buy $5 billion of companies. We need to buy 10 companies. And there's a valuation. So oftentimes, there's a valuation of how much the company's worth based on their revenue, and they multiply that revenue income with a multiplier. It varies from industry to industry. So there's one valuation for high-tech software. The reason is, in high-tech, the cost is very low. The marginal cost to increase your product, if you sell one person, you sell 10 people, it doesn't change. The program's already done. If you're in something that's in manufacturing, the multiplier is smaller. But there's still a multiplier. So it's based on the company's valuation of revenue. And the reason is, the goal of a company is always revenue, revenue, revenue. Because that increases your stock price. And that's quarterly earnings. The other thing I want to mention is when BizDev identifies a company, and I'll just take this as a segue. Now, this varies from company to company. And also varies from where the company is based. So companies in Asia is different from companies in the US, which is different from companies in Europe. And it has to do with the way negotiations are done. At least in IBM, I can talk about them. When IBM comes and does a valuation, they actually come up front and say, we're going to buy your company for $1.3 million or something, or $1 billion. And they don't change that number. There's actually not much negotiations on that. What they do is they actually, then they go due diligence and they identify the actual cost of fixing the company to bring it into the family. And that's generally the way, it depends on the culture. Some other companies, I won't name which one, actually renegotiates based on the price. So they're going to do a diligence and kind of say, oh, it's not like sometimes some people would renegotiate when you buy a house and say, oh, look at this, the foundation's cracked. It's like, that's not crack, that's a crayon. So things like that. It depends on the culture and the reputation of the CEO who does this. You're welcome.
Thank you. Any other questions? Yes, please.
Hi. My impression is that the Asia IP protection is less stringent than the US. Do you agree on that? And if so, is it easier for entrepreneurs to realize their value in the US compared to Asia?
So the question, actually, if I ask a follow-up, when you say realize their value in the US, what do you mean by realize?
Capitalize their value by earning the licensee fee,
okay,
or being acquired.
Okay, thank you. So the question, as I understand it, is there a difference in terms of valuation of IT protection and how it impacts companies in the US versus companies in Asia? That is sort of the general understanding that yes, US does have stronger IP protection. However, that's been shifting, and I think as there's more and more innovation coming in Asia, my guess, this is my personal take on based on what I've seen, they will try to be more stringent on protections in Asia. And it's because you have US companies trying to come in from the market. You want to protect the IP that you're generating. In terms of valuation, whether or not licensing in the US versus Asia, there is more case law, there's more protections in the US, so it's easier to assert a case. And the US is actually pretty friendly for patent holders. For example, there's a couple of court systems that is very fast. They're called the rocket dockets. And there's nothing in those states. Well, I shouldn't say that because I know this is being recorded, but there's less things in those states. But one thing they do have is their court system's very fast and very friendly to patent holders. So what that means is if you're suing in those states, you can get an infringement. And the biggest fear for a company is the loss of revenue. And if you think about it in that form, you can really change the way the negotiation works. So for example, earlier I mentioned if you're trying to license patents to a large company, and I say, well, you want to negotiate the rates. For them, the biggest fear is actually not the rates. Because if I'm paying 2% royalty to you versus 3%, I just pass the cost along to the buyer. But if I can't ship your product from day one, that's complete loss of revenue. Which means that when I buy a company, there's nothing there in the company. So that's why the transfer control provision is so critical in the contract. And that's actually generally what I would say kill a deal, is the inability to transfer control, inability to transfer the license that you signed 10, 15 years ago to the new company that's buying you. And so from a patent's perspective about suing a company, we're generally not trying to sue a company to win the case. We want just simply infringement so it can't ship into the country. So you do an injunction. So actually this is a case that happened, a case of Apple and Samsung. About 10 years ago, Apple and Samsung were wrapped up in a lawsuit, and was about design. The center button on Apple, Samsung looks a lot like Apple, and there was a patent case. And the question was, if it's similar enough, well, Apple may have a good case. We're going to stop all Samsung phones from entering the United States, and they suddenly lost half their revenue. So it's sort of like very mean chess playing. I hope that answers your question. Oh, by the way, if you have any questions specific to your technology, feel free to ask me. Just be careful about it being public.
Hi, Mr. Szeto. I have a question. Well, you talked about the open source material. Are they licensable and thereby monetizable?
So, thank you. That's a great question. So the question is open source licensable and is it monetizable? And the answer is yes, but. And here's the caveat. So IBM Virtual a few years ago acquired a company called Red Hat. Red Hat builds out the Linux ecosystem. The Linux ecosystem is open source. But what they do, the way they monetize it is they monetize it through services. If you want to have the Red Hat system, Red Hat Enterprise work on your software, there's certain things we do. And so what they do is that some parts of the software is open source, some part of it is proprietary. And this sort of duality is how you would try and monetize it. If you have an idea that's, say, based on AI, and you want to find a way of monetizing it, well, one way of doing it is you have some modules that's open source that people can use, but there's some modules that's not. And in order to use your module, your portion of it, which perhaps makes things much better, they pay for it. So you build out the ecosystem, and the value you add, you charge for. But do be careful of the license, because I remember earlier I said that there were a few licenses in here. There we go. There's a couple of the Apache license has an explicit patent grant, which means if you license it under Apache, you're also giving away your license too. So you want to be careful. There's also some other licenses that you have to be careful about. There's an understanding that's, so even GPL says there's no explicit patent grant, but there's sort of an understanding in the community that there may be an implied patent grant. So you want to be careful about those issues.
Any more questions? Yes, please.
Curious, since you talk sort of valuation related again, have you ever been involved where a company was acquired not for their revenue but more for their IP because the acquiring company saw strategic advantage?
That's an excellent question. So the question is, have I ever had an experience where the company acquisition was for the IP and not for the product? And the answer is yes. Actually, in fact, there's a few of them. There was a company that was acquired for their team, for the people. And what being acquired just has this sort of cachet of, oh, I've been acquired, right? So it makes them feel good. So we acquire them, but it's really just for the people. We didn't want their product. There were teams that were acquired for the patent. Actually, one funny thing is there were teams that were acquired not for the opposite. They were getting rid of the patents. So when I was working at Broadcom, some years ago, Broadcom was acquired by a conglomerate called Avago. Now, you may have heard of Avago, you may not have. Avago was very much buying up companies in the semiconductor space at the time. And little known fact to the world is that Broadcom has one of the strongest patent portfolios in the area. By metrics, it says, oh, you know, number 2, number 3, number 4 in terms of patents. But what's special about the Broadcom portfolio, because I had inside knowledge of it, was the patents read on every single competitor in the tech space. And so if it ever needed to sue someone, you can sue someone. The problem was a lot of those competitors were also their customers, so they couldn't sue them. So at one point, there's actually some companies, Acacia, they would actually acquire companies just for their patents. At one point, I thought about doing that. After I left Broadcom, I looked into acquiring Broadcom's patent portfolio. But the problem was, I didn't want to sue people.
Yes, please.
I'm curious about the AI development. Most of the new AI product need data to get it done, but my understanding is that you can't patent data. And how do you basically monetize, or what do you see as a new approach to get money by developing AI products?
That's a great question. So my understanding is the question is, given AI is developed using data, how do you monetize AI in this new regime, this new landscape? Well, AI is very interesting because there's two parts. I see it as two parts. There's a part where you get the data, and the second part is where you build the neural net. The neural net, that part is private. In fact, you can even build in interfaces where they connect to, well, actually, take ChatGPT, for example, or Microsoft, or Google Gemini. You're actually communicating with their server, behind which is neural net that's proprietary, and they're not licensing it. So that's one way of monetizing it. Are there other ways of monetizing it? Well, the way you build out those neural nets is actually very cumbersome. One of the challenges of AI is you need a lot of fast computers. I mean, I know that there was a recent development in China where they blew the world away with a new way of building the AI neural networks. But for the most part, it still takes a lot of computing power. And because of that computing power, if you have methods that are algorithms where you can build out better neural nets that's more specific, the better training, you can probably monetize that. The only reason Google is because they were better at search than everyone else at the time when they first came on the scene. So if you are better at AI communication than everyone else, everyone will come to you, and you become the new Google.
So may I also ask a question? So, I mean, we're responsible for research in the university. So given these, I think many of these concepts are very helpful, but probably very sophisticated for some of our researchers who may be more focused on doing their research. So from your point of view, how do you think a research office could support the researchers so that they are better protected?
Oh, that's a great question. Thank you, Professor Shou. So the question is, how do we better protect the researchers, the faculty,
yes,
and the students who are inventing,
yes,
and to protect their IP? I think it really depends on the personality of the person. So years ago, one of my professors, Professor Tom Layton, he started Akamai, and it was all came out of him and one of his students. And so they created a company. So if the faculty is interested in starting something like this, one way is to sort of build the ecosystem of building a company. In terms of protecting the IP, I think having an understanding of what the ultimate goal is, because most of the times, a lot of IP protection is, so okay, when I was an attorney at a law firm, I just thought about litigation. Can I make the patent litigation proof? Or can I make the patent good to attack someone in litigation? I wasn't thinking about the business implications. And so if you start thinking about these different concepts of, well, how do you make money giving this information, this technology? If it's in, say, chemical processes, then perhaps the process machines, you can sort of have software that sort of makes your chemical process more easier to use or more popular or cheaper or inexpensive. And so everyone adopts it. And so they adopt it based on the software, but the process behind it would be yours, and you can still license that. If it's in terms of building out protection for them to start a company, then I would say the technology office, if you build out the protection, this is where I'm a little bit, I'm pausing, because as a patent attorney, okay, I can't talk about that one, but it'll get me in trouble. As a patent attorney, one thing I found was the patents are very hard to value because it's about words. If you use the word, extension versus the word a flange or a protrusion, each of these words have meaning, and the choice of words determine how valuable your patent is. And oftentimes, one of the difficult things about being an IP attorney is you're under a very tight clock. So you don't have time to think about what's the best way to protect this intellectual property. And so maybe, I'm sure your team thinks very carefully about and works with the intellectual property office, the law firms, to figure out how to best protect the IP. Because I know when I was in the firm, I was just trying to get through my day. Whereas at the company, I was able to stop and think about, does this make sense? Is this patent just purely for numbers, or is this patent going to actually add real value?
Thank you. It's not a simple question. I think my real struggle is it better to educate all the researchers so they know how to protect themselves? Is that feasible, or we need an office or kind of a group of advisors like the way you have in a company, someone like you to advise on all the different projects? And I guess both have their pros and cons, and in a university setting, both have their challenges as well.
Oh, okay, thank you. Yes, I agree. That's a brilliant, very insightful. I have found that one thing I would warn the professors is about publication. Because once you publish, you start a clock of how much time you have before you can patent the protection. And that's why I asked when we talk about very technology that's specific to you, if you're thinking about something and it's private, don't talk about it now because it's public. And that public disclosure starts a clock, and you may end up running out of time before you patent it. So I think the sort of communication, the education is important. At the same time, as you mentioned, having your team sort of help guide them is very important as well, because a certain direction of patenting may actually have different applications. In fact, I'll actually give you an example. When I was at the law firm, I was working with a partner, and she was in the biomedical space. And you may have actually used this product. It's a few years old. It's the idea of using ultraviolet light to reduce fungus on toenails. That was actually patented at the firm I was at. But the inventor didn't think of that initially. They were just thinking about using ultraviolet light to kill bacteria. It wasn't thinking about fungus. It wasn't thinking about these applications. And so when the patent attorney realized this, she was a PhD in biology, she was like, wait, that's actually the big application. That's where the money is. So she kind of teased out the inventor to think about in that realm. And in the process, expanded the strength and value of that company and the patent. So I think it's a joint effort. One is education, but the other also have a team that helps the inventors, the faculty, sort of expand the view into other realms of application.
Thank you. So maybe we have one last question from the audience, if you have one more. Yes, please. Or maybe this gentleman. Yes, thank you.
How do you reduce the cost of filing the patents? You know,
So how do I review the cost?
reduce the cost.
Reduce the cost of fighting a patent. Of filing a patent. Oh, okay. How do we reduce the cost of filing a patent? I would say it's actually kind of funny. When I was at the firm, I have received one-line disclosures where the inventor says, wouldn't it be great if you could press a button and the bottle tells you what time it is? And then I have to actually write 3 pages from that, or actually more like 10 pages from that. Some disclosures are just hundreds of pages long. In fact, one of the clients I worked for was Qualcomm, and they gave their standard, and they gave us the entire standard and say, Ray, we want to protect this aspect. And I have to read the entire standard to figure out what I'm supposed to be patenting. I would say the best way to reduce the cost of filing, well, there's 2. One is negotiations. Oftentimes, if you are a university or if you file many patents, you can probably negotiate a fixed rate. Now, there's a problem to that, because that means if you negotiate a fixed rate, the attorney on the other side knows that there's a fixed number of hours you spend on it. And I'm pretty sure that having been on the fixed hour, I try to get it done within those hours, and it may not work very well. So I may not actually file a very good patent. On the other hand, if you give me a patent disclosure that's very similar, you know what? This is something I never thought about, and this is actually kind of new. Use AI to help you. Use AI to help you put together a good disclosure. And if you have figures, give them the figures, because that way they don't need to draft any more figures. It actually takes away a lot of the work, and by taking away the amount of time I spend doing it, I can put more time into thinking about better claims. I can take more time and build a better patent for you. And that's the way I would do it. I have filed a patent for myself at one point, and looking at sort of priority, if you take enough steps back, you can actually make a very strong patent. But you really need time to think about these things. So I guess reduce the workload for the attorney.
So thank you, Raymond. I hope you are all like me. I learned a lot from this section. I think a lot of these issues are very important for researchers, especially those aspiring to start companies and to have their inventions protected. You should find them very helpful, and we're very grateful that Ray comes all the way to CityU from Boston to give us this important lesson. And I hope that you all continue to learn from this. And this may be too short to give you all the education you need, but hopefully raises your awareness when you are doing your next discovery or invention. So please join me to thank Ray once again.
Thank you very much for the honor. And feel free to contact me if you have any questions.
Thank you.
Thank you, Professor Yeung.
Thank you.